The Indian Child Welfare Act is a federal law that seeks to keep Indian children with Indian families. It was passed in 1978 in response to compelling evidence of the high number of Indian children that were being removed from their families by public and private agencies and placed in non-Native families. Prior to the passage of Icwa, approximately 75 to 80% of Indian families living in reservations lost at least one child to the foster care system. Child welfare agencies were often ignorant, indifferent, or insensitive to cultural differences in children rearing and parenting practices, and as a result, many unnecessary and unwarranted foster and adoptive placements were made. Icwa was enacted to protect the best interests of Indian children and to promote the stability and security of Indian tribes and families. It established minimum federal standards for the removal of Indian children and provides guidelines for the placement of Indian children in foster or adoptive homes, which reflects the unique values of Indian culture. Icwa protects the interests of both Indian children and tribes. In the context of Indian welfare law, protecting the interests of a tribe in its children is unique. Underlying premises of Icwa is that the Indian tribes have sovereign rights and legal powers with respect to Indian children, and having vital legal role to play in determining whether Indian children should be protected from their families or separated from their families and their culture. The Act recognizes the authority of both tribal and state courts to make decisions regarding welfare, care, custody, and control of Indian children. The Act also provides assistance to Indian tribes in the operation of tribal child and family service programs. This is why I became a foster parent. We were watching our Native children being taken off the reservation to live in non-Native homes. I understand why they do it because there weren't very many Native homes to take the children to. When we started fostering, there were only like 9 or 10 Native foster families that took children on our reservation. We didn't want to see our Native children in non-Native homes. But sometimes that couldn't be helped. The family would not or could not take the children. Around the reservation, many people are caring for their nieces, nephews, and grandchildren. Many times, relatives wanted to take the children but they couldn't because they were using in the home or had substantiated claims. This is why we need more people to be foster parents so they can stay and be a part of a community they already know. Be in homes that are enriched with cultural values and traditions. I look at my own children and know that if we didn't become foster parents at that particular time, who knows where they'd be. I do know that they would not be in the same home, and I do know that they would have been adopted to non-Native families. When my son was a baby, he was with a non-Native family. I knew he was out there, and I wanted him here with his other siblings. We did have to fight for him to come home with us. The state dragged their feet in bringing him back to the reservation since the other home already had him for 6 months. It took them some time, but he is with us and his sisters. They are powwow singers and dancers, participate in Sweat and Sundance, and I feel good knowing that whatever challenges they have, they will be able to weather the storm because their native culture and traditions are embedded into them, and they have each other. Icwa was challenged in the case of Haaland versus Kraken. The Supreme Court addressed the constitutionality of Icwa, upholding its validity 7-2. Non-natives claim that non-native adopted parents were being discriminated against. It would take an act of Congress to pass a legislation governing tribal affairs. Icwa is seen by many as a vital tool to protect tribal sovereignty and the rights of Native children to maintain their cultural ties. More recently, Jonathan Windyboy of Montana blasted to the floor with a procedural move to remove a sunset provision from the Montana Indian Child Welfare Act. This law would go beyond the protections in federal law. It is based on sovereign status of tribes, ensures they have a connection to their tribes and culture. It ensures that if there is a termination of a legal relationship between parent and child, the parents must be notified every step of the way, and that if any officer influencing foster care or parental rights must demonstrate they have participated in active efforts to prevent the breakup of an Indian family. The bill passed 31-19.